Well, this is it. I'm the only thing standing between you and whether your parking is going to get validated. So I will try to conclude relatively early. That was a California joke for those of you who don't get it. This being a conference on biosimilars, I thought it would make sense to look at the objects of many reference biologics, antibodies, and to the state, the perilous state, I would argue, of antibody patents. In short, a recent Federal Circuit decision, this Amgen versus Sanofi from 2017, threatens to lay to waste a vast landscape of antibody patents, potentially upending our system of biosimilars and biosimilar innovation. Let me explain. Antibodies are the biologic reference of choice. 6 of the top 10 selling drugs in 2017 were antibodies or fragments of antibodies, including Humira, the best-selling drug in the world, netting its manufacturer AbbVie, depending upon how you do the accounting, the darkest of the dark arts, $20 to $30 billion a year. Despite this, antibodies are complex. They are some of the most complex biologic molecules that in many ways resist chemical characterization. And man, we saw a lot of slides about this today, right? If we want to put it in words, I think Artie Rye and Nicholson Price here put it best, right? I'm just going to quote them directly. In terms of size and rough complexity, if an aspirin were a bicycle, a small biologic would be a Toyota Prius, and a large biologic would be an F-16 fighter jet, end quote. To further the analogy, nobody characterizes an F-16 fighter jet by listing in detail the size and torque of every screw and nut or bolt put on the plane. The whole, in some senses, obscures the parts. And so, perhaps because of this complexity, and as a matter of history and scientific convention, antibodies are thought of in the immunological field in functional terms, specifically what they bind to. The antibody, anti-CD37, for example, binds to the protein CD37. Anti-PCSK9 binds to PCSK9, anti-CD47 to CD47, and so on and so on. They're named this way, they are researched this way, and ultimately, and importantly for our purposes, they are claimed in their attendant patents this way. The problem with this, of course, is that this touches upon one aspect of the written description requirement in patent law that prohibits functional claiming like this without disclosing sufficient structural elements of the claimed invention or a, quote, representative number of embodiments. And it's this tension between science and doctrine that the Federal Circuit seized upon in Amgen versus Sanofi to essentially declare Amgen's anti-PCSK9 patent violative of the written description requirement. Given that Amgen's patent did nothing different from what hundreds of valuable antibody patents do in the field, this decision threatens the patent landscape for biologics as we know them. So I'm going to unpack all of this by first talking about functional claiming and the written description requirement. No better way to end a day than to talk about 112. It's what I do with my spouse before we hit the sack, right? I'm then going to show how this typically applied to antibody patents and how it hit a brick wall in Amgen versus Sanofi. I'm next going to describe some on-the-ground implications for this decision. And last, I'm going to conclude with some thoughts about what this means or is likely to mean for biosimilar litigation going forward, right? So, functional claiming and written description. Let's do it, right? Generally speaking, for patent claims, one needs to claim the structure of one's invention, not its function. And the reasons for this are simple. Claiming an invention by what it does, rather than what it is, threatens to propertize more than an inventor actually claimed. Claim jumping, if you want to use the parlance of the Old West, right? Perhaps an example can make this clear. One cannot claim, a la here, a, quote, machine for flying, end quote, if all they have invented is this whirligig, right? Allowing them to do so would also threaten to possess aeroplanes helicopters, zeppelins, hot air balloons, and so on, even though our inventor may never have been in possession of these things. This seems simple enough, right? But the doctrine has recently experienced some newfound vigor after some significant functional claiming problems were documented in software. From a scholarly perspective, this was perhaps most notably written by Mark Lemley, Colleen Chen, and Kevin Emerson Collins, right? At the same time, it, at least until recently, received less consideration in the wet sciences because it was long assumed that chemical compounds could easily be described and patented structurally. The ball and stick figures of high school chemistry, if you will, right? To be clear, this does not mean that functional claiming is verboten under the statute. Rather, the Federal Circuit has made clear that functional claiming is limited to two instances, right? One, where it's accompanied by sufficient structure to clue a person having ordinary skill in the art as to the limits of the invention. Two, where the functional claims are nonetheless accompanied by a disclosure of a, quote, representative number of embodiments of the full scope of the claims. Either way, for wet science patents, this seems to impose few barriers to obtaining robust patent protection for molecules. That is, of course, until one considers antibodies, right? Antibodies are some of the most complex, if not perhaps the most complex, biologic molecules known. Their object, as part of the immune system, is to bind to latch on to, foreign proteins in the hopes of signaling the rest of the immune system to attack their target. Given that a number of possible foreign proteins is virtually infinite, right? We do not know what bacteria hold in store for us today or tomorrow or a billion years ago or a billion years hence. This poses a problem of scale, right? The genome, our DNA, cannot code a separate antibody for every foreign protein that could ever be produced by bacteria, viruses, and other invaders. So antibodies are produced like this, by a random arrangement of snippets of 3 to 4 genes, easily remembered as the letters V, D, J, and C, by essentially cobbling together bits of random bits of words to make a given antibody's book, like that old Bob Newhart joke about monkeys and typewriters eventually creating Hamlet, right? Eventually, a sufficiently diverse set of antibodies are produced such that at least one, and possibly many more, will bind to a specific malignant foreign protein. This diversity in antibodies is galactically complex, and I mean that literally. There are roughly 100 billion possible different human antibodies based on these random arrangements. That is, roughly speaking, within an order of magnitude, if I have any cosmologists in the room, I'm sorry, roughly speaking, about the same number of stars in our Milky Way, right? One consequence of all of this is that scientists think of, research, and refer to antibodies not by the particular genetic sequence that gives rise to them, but by what they bind to. Indeed, referring to antibodies by their genetic sequence produces something of an incoherency because many genetically different antibodies could all bind to the same antigen, producing the same biologic result despite their genetic differences, right? Antibodies have been the workhorse of molecular biology and immunotherapy since the mid to late 1970s, and they've also been subject to a broad array of patents and claiming techniques. In their most modern incarnation, the ones protecting virtually all commercial antibodies sold today, patent attorneys have gotten around this disconnect between the functional recognition of antibodies and functional claiming, by claiming, instead of the precise structure of the antibody, the precise structure of the antigen to which a class of antibodies bind. So, let's give an example, right? One biotech company, MorphoSys, has a small patent estate covering antibodies that bind to one important signaling molecule, CD38. MorphoSys' patents claims, accordingly, are directed to, quote, an isolated human antibody that specifically binds to an epitope of CD38, and they define that using a genetic sequence, right? To be clear, the genetic sequence of the target, not the antibody, right? This has long been assumed to be proper claiming strategy, and the Federal Circuit gave it explicit approval in 2002 in a case called Enzo Biochem versus GenProbe. But the revolution, or maybe a better phrase for it these days would be the revolt against loose written description standards, began to take root in 2005 with this case Ariad versus Eli Lilly, which concluded that written description was a statutorily independent requirement, counseling against broad classes of molecules even if they are functionally similar. And if one stops and thinks about this for a moment, especially armed with some basic knowledge of antibodies, which hopefully I have provided you, this is all traditional antibody claims are, right? Claims directed to a broad, in some cases vast class of structurally different molecules that are grouped together only by their function. The Federal Circuit began to view antibodies with some skepticism following this Ariad case, but its touch was light, and in some cases it was fact-specific, right? And then comes October 5th, 2017, where the Federal Circuit announces Amgen versus Sanofi, a case concerning whether Amgen's claims directed to an antibody that bound to a protein called PCSK9 met this reinvigorated written description requirement, right? The court there concluded, by and large, that it did not. Amgen's claims, like virtually all commercial antibody claims, describe the structural specifics of the antigen, right? That is the target, right? And it even included some limitations about how tightly the antibody needed to bind to the antigen, right? But it was devoid of detail of the genetic sequence of the antibody or class of antibodies themselves, right? This, the Federal Circuit concluded, was not so much like claiming a key by describing structural features of a lock, but more like a lock and a ring with 1,000,000 keys on it, right? In reviewing Amgen's claims, the court declined to state, as a matter of law, that, quote, a functional genus claim to corresponding antibodies is one in which the underlying science equates to the required description of the claimed products. This, the court concluded, was a factual scientific proposition that could, in theory, be litigated on a case-by-case basis. But given the realities of antibody science, this law-fact distinction is unlikely to do significant work. If Amgen's anti-PCSK9 claims failed, then so do a swath of the antibody patent landscape, right? Let's talk about this patent landscape for a moment so we can understand the magnitude of the problem. As I mentioned earlier, antibody patents are incredibly valuable. There is a good argument to be made that they are the most valuable patents that we have in the whole of the United States patent system, or the world for that matter. If just under 100 antibody patents protect Humira, as Nicholson informed us earlier this morning, this is, again, the world's best-selling drug, again, depending how you do the accounting, about $25 billion per year, more, by the way, than the entirety that the NFL makes, right? One drug, right? That's a far more impressive royalty value per patent than the thousands or tens of thousands of patents that cover complex consumer products like the iPhone, right? That's about, I realize this is not the appropriate way of doing the math, but that's about $250 million per patent, right? That's a lot of money, as we like to say, right? Not only that, but Humira is not even an exceptional case. 6 of the top 10 selling drugs are antibodies, are fragments of antibodies with patents that are virtually identical to Amgen's struck down PCSK9 patent. And while small molecule research in big pharma has greatly stalled, the future of molecular therapy is largely biologics, like antibodies, predicated on a significant assumption that they can be protected by composition of matter patents, right? This applies to patents covering not merely the composition of matter of the antibodies themselves, but methods of manufacturing these antibodies, as we have also heard today, methods of treatment using these particular antibodies, as Brenda was just telling us now, right? They too claim antibodies, right, that serve as elements of their claim functionality, right? Structural limitations that are specific to the antigen and not the antibody. There is no reason to expect that they're going to be treated any differently from Amgen's claim, right? And it's not like these issues have not attracted the notice of practitioners in the field and parties. There are some significant cases currently being litigated where the primary issue in dispute is the validity of certain antibody patents post-Amgen versus Sanofi. The morphosis example that I gave earlier comes from a dispute, morphosis versus Janssen, currently being litigated, District of Delaware, right? Morphosis has claimed that Janssen's Darzalex product, which is an antibody, infringes its patents. Since the case was filed in 2016, Janssen has since redirected the litigation to make the most of this Amgen versus Sanofi case, and a trial is now expected soon just on this written description issue, right? Another dispute concerns a recently established company. Do I have a slide? Maybe not, right? Called 47, right? Another significant, which has significant patent protection around a target, CD47, hence the clever name, right? It's critically important target for a wide variety of cancer treatments, and their patents are similarly being challenged by competitors. After Amgen, it seems that no antibody patents are safe, right? All right, so what does this say about biosimilars, the topic of this conference, right? I think it says a few things, although time will tell whether these predictions come true as a consequence of the anti-PCSK9 case or whether my alarm is simply alarmist, right? If it's the former, I expect that the morphosis case will serve as a bellwether for future wins, right? So let's see. First, I think this essentially means that no composition of matter claims for antibodies currently on the books, and including those for products that are yet to be approved by FDA, are likely to satisfy the written description requirement. This will be a tremendous blow to companies doing early stage antibody work because these early composition of matter antibody claims is much of what they claim as value, especially when they are initially seeking funding in the Series A and Series B round, as did our company 47. It will also be of significant impact to currently sold reference biologics because they will no longer have the strongest protection to fend off biosimilar entrants. The actual consequences of that, I think, are actually a little bit more nuanced and complex, and I can talk about some of those in the Q&A, but all in all, I think this makes litigating biosimilar cases markedly easier for biosimilar manufacturers. Second, I think it also forces a shift in BPCIA litigation away from patents covering compositions of matter and methods of treatment, right? Away from patents covering compositions of matter and toward methods of treatment, the kind of current weapons of choice in the 100 Years' War that tends to be BPCIA litigation, right? Rather, we're going to move closer towards manufacturing technologies. If you can't claim a broad antibody genus, then you could at least claim methods of making a broad antibody genus without failing the written description requirement. At the same time, right, these manufacturing patents are likely to be less easily infringed, meaning they can more easily be designed around. There are many paths to the top of the antibody mountain, right? And in addition, much of the manufacturing of biologics is protected not by patents, but, as Nicholson informed us earlier today, trade secrets, meaning these issues won't even come out in the typical BPCIA litigation patent dance in the first place. So here too, the upshot of Amgen at the very least is that it seems like it's going to be an easier time for biosimilar litigants, even if manufacturing tends to be more difficult, right? Third, without composition of matter protection for antibodies that target specific antigens, but with their disclosures documented in the same patents, companies may be more enticed now to start from scratch, to develop new antibodies specific to the same antigens that have previously been disclosed, but now are no longer protectable. In regulatory parlance, what I mean to say is that we may see an uptick in the filing of new BLAs that target the same antigen rather than a filing of ABLAs, right, abbreviated biologic license applications. Or to put it yet another way, right, less biosimilars and more Me Too reference biologics. This has already happened to a certain extent in the biologics world, where 3 of the top 10 selling blockbuster products all target the same antigen, tumor necrosis factor alpha, right? Without composition of matter protection for antibodies, this may encourage similar behavior, right? All right, that is pretty much it. I am done, and I will take any of your questions. You will notice I have not provided any prescriptive solutions whatsoever, and that's because I have none, right? So yes, thank you very much. Happy to take questions. All right, Nicholson.
This is so interesting.
Thank you.
What fascinating predictions. So I'm curious as to how can we measure what are we going to see if you're right? Are we just going to see more stuff by the CAFC invalidating things, or are there other signals we should work for? And B, do you not have any predictions because you are not there yet, or because you don't think there's a problem?
Great question, right? So let me start off by I've essentially proposed what I think is actually a testable hypothesis, right? So what exactly is that testable hypothesis, right? Well, now that Amgen versus Sanofi is out, and not only is it out, but the mandate has issued, and not only has the mandate issued, but the patent office has issued new written description guidances to its examiners about what to do with the Amgen versus Sanofi case now. So it's really like on the books as far as on the books go. So the question is now, I think, are we going to see 2 things? Thing number 1, these cases that are currently being litigated, if they all die, right, if these composition of matter antibody patent claims all die, then I'm right, right? So no, you asked me, I have a testable hypothesis. This is the testable hypothesis, right? If they all die, then I'm right. So let's find out what happens in the morphosis case. Let's find out what happens in the 47 case and a bunch of other cases that are being litigated now. That'll be, like I said, a good bellwether to see what happens now. The other thing is we can take a look at antibody patents that are being filed right now. Are patent prosecutors really kind of shaking in their boots, or are they not going to do this stuff? Or we are going to start to disclose some cDNA sequence? Are we really that kind of worried about it? That would be interesting to note, right? So and obviously the opposite of that would mean that I'm wrong, right? If 47's patents survive, and if morphosis patents survive, then I am wrong, and this is not the firestorm that I think it's going to be, right?
Was there a cert petition?
Yes, there was. Cert petition got denied. That's why the mandate issued January 9th of this year.
Tons of amicus from.
Oh yeah.
Huh.
Oh yeah. I mean, I am here bringing the fire down the mountain to academics because we are all swimming in the primordial soup, right? So this is essentially what I'm doing here. We like to think that it's the opposite, right? That it's us sitting at Mount Olympus, but no. Anyway, right? So that's one thing, right? In terms of my lack of prescriptive solutions, right? I mean, I've got a pretty simple prescriptive solution. And it's like, give us some cDNA sequence. Right, and there's definitely ways of doing about this. But man, let me tell you something about genetic sequences, right? Like there's a declension problem, and so you start providing some cDNA sequence, and all of a sudden it gets really easy to not infringe. It gets really easy to design around, right? And there's a percentage like homology limit that the patent office is willing to accept when it comes to claiming. Right, so I've got a solution that will do it legally, but I think doesn't do it economically, right? So I don't know. Anyway, there we go.
Just with my business school professor hat on, this also, to me, implies that the business models for how we do antibody drug development, might change a lot. So my understanding of what MorphoSys does as a company is they have the world's largest antibody library. And so my first thought was oh, they're screwed. Right, if Or not, though, maybe not, right? So the flip side of that is if they have the world's largest antibody library and now there's all this opportunity for Me Too biologics, then like maybe they're sitting pretty, but it's definitely like it seems to have, this is just an observation, but how companies are structured there seem to be big implications of this for like how successful companies like MorphoSys are likely to be 5-10 years from now, because they've built their entire business model around having the world's largest antibody library.
Yeah, so on the MorphoSys issue specifically, I think that, again, assuming that I'm right, which I'm not actually like internally assuming I'm right, I'm just saying like to answer your question, assuming that I am correct, right? Companies that do early stage research and licensing, that is essentially what MorphoSys does. Right? MorphoSys has no approved product, nor do they have any plans to have an approved product. Right. So companies that do early stage research and licensing, like I think they are in fact screwed, kind of period, full stop, end of story, right? I mean, I think that's
if that's currently your value add.
Yeah, right. So I mean, that's what I think the issue is. I think one of the things that will be more important, I forget who was saying this earlier, as we narrow the window from the kind of initial basic discovery to commercialization pipeline, then I think companies there are kind of less concerned about this stuff because, maybe we are going to get another BLA competitor out there, but like it's not like, Humira with the two other Me Too TNF alpha antibodies is like hurting for cash. I would love to sell a product that netted $25 billion globally a year. I wouldn't care about competition then, right? So yes, I mean, I think that's particularly tough. And an interesting flip side to this is that the other company I mentioned, 47, which is doing a lot of research, right? They are essentially the opposite of MorphoSys, right? The same CSO board are the people who did the basic research at Stanford to, figure out that, CD47 is the don't eat me signal on antibodies. This is going to be really important if we're able to kind of mediate that signal. And so like basic research to commercialization, same team all the way through. They're the ones who want to shepherd it. They're not looking to partner. They're not looking to sell. And so, that seems to be I guess assuming I'm right, I guess that seems to be the model of the future. And kind of oddly enough, like I think that's kind of what we want. Like we want more of that stuff and we want less of that. We've got a bunch of antibody libraries. We're going to get a bunch of patents and sue a bunch of people, right? Like I think just like normatively, that's what we desire, right? And so, yeah, I don't know.
Sorry, and to be clear, like I was making a positive.
No. Right.
I'm taking that to its logical conclusion. It have implications for like business models in biopharma.
Yeah. I mean, if I were MorphoSys, like the day I lost my case, assuming I'm going to lose my case, like I would then hire a bankruptcy attorney. Anyway. All right, so you guys are really hot in Section 112. Thank you very much. It has been an absolutely wonderful conference. Thank you so much for attending. I know that Dan Burke sends his regards to, I know that he regrets not being able to be here. This has been wonderful, and I want to thank all of the staff and the video people and the PR people here at UC Irvine for making this just an absolutely wonderful conference. And I can think it's fair to speak for all the academics who spoke today here and everybody else that we would all love to come back to sunny Irvine and speak about these topics again. So thank you very, very much. Thanks.